that's happening. So
awesome.
We'll get there. You know, it's
All
hard
right.
to track down Martinez, right? I mean, where is he? What's
Yeah.
more important to Martinez than being on this right now?
He's allegedly in a hearing. Allegedly.
Okay.
Kind of like lawyers allegedly have feelings.
Allegedly.
Anyhow, let's tell folks what we're here to talk about today.
All right, let's jump in.
I've entitled this show Collateral, Latent, Unanticipated Consequences of Criminal Cases. What do I mean by that? People who have been through the criminal justice system understand that there's more at stake when you are arrested and accused of a crime than just being prosecuted and the potential for jail, some sort of incarceration. But people who have not been through the system don't necessarily understand that as being the case. And when you're in the system, if your lawyer is not sufficiently attuned to these collateral, latent, and unanticipated consequences, then you can find yourself in a boatload of trouble sometime down the legal pike. So one of the things that we're always careful and considerate of are these latent, collateral, and unanticipated consequences so that we can advise our clients accordingly and try and avoid them or dodge them or prepare for them as the case may be. Just by way of real brief example, I listed a whole bunch on my Facebook post today, but the easiest one to talk about is criminal records and criminal history, right? You can beat your case. You could be acquitted. You could receive an apology letter from your arresting officer and a ticker tape parade down Flagler Street. But that won't change the fact that there was a public record that you were arrested for X. And X could be a disqualifier for you sometime down the road, even if you seal and expunge that acquittal or dismissal or whatever it is that happens to that case. I'll give you a classic example. And I don't mean to take too much time, but bear with me for a moment, Mark. So many years ago, I represented a lovely young lady, early 20s, worked in a bank, a Chase Bank in Surfside. She was a teller. She was a very sweet girl. And she called me that was my local bank at the time. I lived in the neighborhood, so she knew me. Everybody in the bank knew me. And she called me one day hysterical. She had been arrested for grand theft. Apparently, at the end of her shift, she was $3,000 shy. And they stayed in the bank until about 11 o'clock at night, counting and recounting and calculating and recalculating, and they could not find the $3,000. After a couple of days, bank management wound up reporting it, and she wound up getting arrested. They actually charged her with theft. They believed that she had pulled a fast one with somebody that she knew who came in and maybe did some kind of a transaction or what have you. Well, long story short, if possible at this point, several months into the case, the bank did a retrofit, and when they tore apart their drawers and they pulled all the cabinetry out, there was the $3,000 sitting in the back there. They were profoundly apologetic. They immediately called the state and asked the charges be dismissed, and the state complied. They agreed. This young lady who never had any type of criminal past, never did anything in her life, had a grand theft charge that was dismissed. I subsequently expunged it. 6-7 years go by. I get a call from her from Texas, and she told me that she was denied housing. She had tried to rent an apartment, and she wasn't able to get it because of that expunged grand theft charge from years and years earlier from out of state. So it's that type of a thing that I would call a collateral or a latent or an unanticipated consequence of a criminal case. I mean, you don't get a much better resolution to any case than the victim coming to the state attorney and saying, we made a terrible, terrible mistake. Please drop these charges immediately. And look at that, all the way down the pike, this poor young lady was unable to rent an apartment because her landlord didn't want to rent to a thief. So there you have it. That is what we call a collateral, a latent, or an unanticipated consequence.
Right. Well, when we talked about this topic yesterday, when we were throwing around some ideas. That's exactly what I wanted to go all the way back to the beginning, because I think we take for granted many times that the system. We talk about the system every day, but the system isn't. I don't know how to give a good analogy to it, but once you're in it, you really can't get out of it. Okay, even if a bank comes into the government and says, "Hey, we made a mistake," but I don't. I'm going to just mention this, and then I want to go back to piggyback what you were saying. But anybody that's watching this right now that is going for a job interview or a housing application, anything like that, that is going to require a background check, simply run one on yourself. Okay, spend a little extra money, go on the internet, find a good company that runs background checks, run yourself, and see what comes back on it before somebody else does.
You could do that right through FDLE. They do level 1 and level 2 background checks for the public.
Perfect, and you don't have to spend. Yeah, I think it's $10, but
yeah, whatever it is, it's cheap.
Worth every penny. So it starts, Mike, right away when the police pull up. And you don't have to be a defendant. You could be a witness. You can be on body cam. They can take your name down. Someone can point you out, witness. But if you get those bracelets put on you and you get in the back of that police car, you are now in the system. And I don't, what's reversible about that?
The system. The system.
Right. So, many people that are watching here have been in the system, are in the system, know people that are in the system. The system will eat you up, and the system costs money, okay? We were talking about that last night. You don't just get in and out of the system and it's free. Hey, no. And I got carried away. I was talking about court costs if you have to settle your case, when you're paying the clerk, restitution, an attorney. It is an expensive proposition. And how about, we also talked about this, how about you get arrested, right? You go to jail. You can't make bond right away. You're sitting in. Who's taking care of your stuff? What if you have a place? You got a dog. You got food in the refrigerator. You got bills to pay. You have a job. Forget about it. You're not going anywhere. So your life.
These are collateral consequences. These are collateral consequences.
Yeah, they're not only collateral, but they are terminal to some degree.
So let's say you get pulled over for just a basic traffic offense. What's the first thing that officer does after they get your driver's license?
They run you.
They run you.
Or what's the first slang is that they will take, they'll take your license. They have high-tech computer in their police car. Well, they want to know who you are. They want to know if you could possibly be carrying a weapon, if you were wanted, warrants, things like that.
Apart from warrants or other red flags, let's just assume none of that exists because you're just an average guy or gal who has no history with the law. Here's what they're going to see: your driving history. Okay, I mean that's the first thing they run. So your silly traffic ticket that you thought was gone, which will always for the rest of your life appear on your driver history. I mean, they can only count points against you if they're assessed for 3 years, but the entries never go away. I have entries on my driver history from when I first got my license in 1983. They're there. Sure. They never disappear. It's a collateral consequence. It's not an arrest, but still, the police officer that pulls you over and sees the system. That police officer that pulls you over and sees that you've received 10 tickets will treat you differently, more than likely, than an officer who pulls you over and sees no tickets. So it's another collateral consequence of being in the system.
Right.
Your name is in it. Your identification is in it. Sometimes there are people who have very common names who wind up being confused and have identification issues with actual people. And then even worse are the poor folks who have a black sheep relative.
How about a twin brother? I have a story about a twin brother, but
in and out of the system, and they get pulled over, and the first thing they say is, "Oh God, I'm so sorry, officer, I left my license at home, but here's my name and date of birth." And then the next thing you know, it's the brother or the sister or the cousin or the best friend or whoever that winds up with a problem that they never even knew about because they had nothing to do with it in the first place.
Well, so, when we talked about this last night, we can tell people here a lot of what they already know. Okay, they already know what it takes to get in the system, how you get there. But I also want to approach it from the view of, okay, you're in the system now, your case is being litigated. You need an attorney that knows the system and that can navigate you out of the system as best as possible. you're already in it. By the time, like you said, you're booking photos, there's a picture of you, you're getting booked in. Geez, how long does it take to get bailed out when you're going to get bailed out? How many times have we asked that question or clients asked that to us? How long will it take me to get out? Well, I know you've had, I think you had Russ on your show earlier as one of your shows.
A couple of weeks ago.
Okay, Russ Walters is, top of his game, and he explains to people all day long, every day, why it takes so long to bond somebody out. You think, hey, Russ, I'm I'm transferring money to you. When can I go pick up my brother? Well, it's 2:00 right now. I don't know if we're going to get him tonight. And it's not for lack of trying or bullshitting. He just is not going to be, it's the system. But again, if you're looking to hire an experienced lawyer, okay, which you always want to do. I don't ever hear people say, I want to hire a very inexperienced lawyer to help me. It can end up saving you a lot of money to have a lawyer that knows how to navigate those areas of the law that can cost you a lot of money, okay? Just even something like this came up too. I think you mentioned it to me. You're closing your case out, okay? And there's going to be all different types of, let's take probation, for example. Probation, cost of supervision, if you have an ankle monitor, all these things could add up to hundreds of dollars a month. But you can simply ask the judge, Your Honor, would you consider reducing the cost of my client's expenses for his probation right now while he gets back on his feet and starts earning a paycheck, whatever it is? And I find a lot of judges are extremely sympathetic to that and will lower that. They may do a ladder, meaning, okay, no fees this month. We're going to bump it up to 15% next month, and then you slowly work into it. And you should be working and having a job.
What you're talking about is what good lawyers, what effective lawyers do, and that is anticipate these types of collateral consequences. If we know that we have a client who's going to be facing probation, we discuss that with the client, right? There are standard conditions of probation that anybody and everybody who is in the state of Florida that is on probation is required to abide by. And some of those are very restrictive conditions. For example, you effectively lose your Fourth Amendment privilege, right? They don't need a warrant. Your probation officer does not need a warrant or any type of notice to show up and conduct a thorough search of your home or your car or your person.
They'll tell you, we're going to do a walkthrough. They may tell you when it's going to happen. But I think, Mike, you can, you've done this too. You've done written plea agreements where your client has signed every page that they are subjected to a polygraph in a lot of cases. Now, that's a lot of mostly sex offenders. Obviously, that's something that's critical. But, when you're on probation, you've got 1 foot in jail already.
Isn't it funny how the state attorney will never accept a polygraph in the defense, but they love to order polygraphs on their own when it suits them.
Yeah.
When we want to present the polygraph, they tell us don't bother. It's a waste of time.
You know what? That's fine. I just put it if my client passes it, I put it in the court file anyways.
So let's talk a little more about probation, because apart from the standard conditions of probation, there are other conditions that we can reasonably anticipate, right? Depending upon the type of case that we have, we can expect that there are certain people that the judge is going to add or the state attorney is going to successfully request additional conditions that are above and beyond the standard. We call, they're custom conditions of probation. And judges have blanket authority to do that. And unless it's outrageous, they get complete deference by appellate courts. So they're entitled to structure conditions in terms of probation that are tailored to the individual. Right. And the more that we know about the individual, the better we are able to anticipate those potential pitfalls down the road. It's one of the reasons that you and I tend to take what we call a global approach to client assessment and client management, where we learn as much as we can about the individual, about that person, about his family, about his specific needs, or her job, or her requirements, or travel. There's a
PSI, basically.
with probation, you're generally restricted to the jurisdiction of the court unless you have authorization from the court to go somewhere else. So what happens if you are a parent with young children and you want to go to Orlando, to go to Disney World for the weekend? Or what if you're a guy with a boat who wants to go to the Keys and go fishing?
Too bad. But you know this is my position, and to some extent it's yours too. I don't like probation. It is not for everybody. Okay, it's a trap most of the time. And when I say that, your listeners, when I say it's a trap, here's what I mean. It's not jail, so if it's offered by a prosecutor as an alternative to jail, hey, your client's gonna have to do 3 years reporting probation, all those conditions you talked about, travel, drug testing, all that. To me, I learned this when I was a prosecutor. Okay, maybe I don't have a strong case against you, Mike. All right, so I will offer you probation, but let's say it's a third-degree felony with a 5-year, 60-month max out. Okay, and what I mean by that is if you are convicted of a third-degree felony, you cannot do more than 5 years statutorily. So let's say you've been in county jail for 8 months, and you take a plea on that 8th month, and it's to, let's say, a 3 years probation, special condition. Let's say it's a grand theft, restitution. And then you always tell people, if you're going to be successful on probation, you do what you're told, when you're told, how to do it, and listen to your lawyer, those certain rules. But there are certain prosecutors out there that know that certain individuals are not going to make probation. Because I know that a lot of times. But at the end, it's not my decision, it's the client's. But what they're looking to do is to violate an individual because their case against that individual is not that strong. Because when you violate probation, first of all, it's very simple to violate. The burden of proof is completely different. There's no jury trial. There's no beyond a reasonable doubt. It's you and the judge and the prosecutor telling the judge to hang you.
And it's a kangaroo proceeding in some other ways.
But you're on the hook. Right. How long are you on the hook for if you pled to a third-degree felony and you had 8 months, which is a lot, under your belt in county?
4 years and 12 months. Well, again, that's almost,
you can't fight it.
You can always fight it, but
while you're in jail,
a probation violation is a stack deck. And we could do a whole show on probation violations, and in fact, I think we should, and we will.
I have a video called "The Probation Trap." It's quick, but I talk about this topic.
So that's definitely a collateral consequence is the possibility of facing a violation of probation, which, as you accurately point out, is a veritable slam dunk for the state. They have one burden and one burden only. And that is to show the judge that you, quote, willfully and substantially violated any term or condition. And any term or condition could be as easy as not reporting or failing a drug test.
Well, not reporting during probation, people are like, okay. No, that is your main responsibility.
Right.
Where are you?
Or you get a speeding ticket. A speeding ticket is not a violation of probation. They cannot violate you for getting a speeding ticket.
But they can violate you for talking shit to the police officer.
They can violate you for failing to disclose the fact that you got a speeding ticket and had an encounter with law enforcement to your probation officer. So that's part of the probation trap, right? Because how many people think about that? Well, you know what? It's one of the things that we, as lawyers, tell our clients. We instruct them. It's not enough that probation instructs them as they're required to, or that the judge does. It's our job. And unfortunately, we find way too many attorneys who do not do their job. How many people come to us after a case and say, oh man, now I'm being deported. Nobody told me I was going to be deported. Well, there's another collateral consequence. It's called immigration. If you're not a United States citizen, any plea to any crime or any contrary verdict to any crime subjects you to deportation. Doesn't mean you're going to get deported, but it means you could be deported. It means the collateral consequence of being booked into a jail if you're a non-U.S. citizen or if you're even here on a visa is that there can be an immigration hold placed upon you.
Absolutely.
Meaning smacks a document down on the Dade County or the Broward County or whatever jail and says, do not release this person to anyone but us. And therefore, you go ahead and some family member posts a $10,000 bond, they're out of pocket $1,000, and guess what? You ain't going anywhere. That bond is posted. The next stop for you is Chrome.
You're going to Chrome, is where you're going.
Exactly. That's the next stop. And now you have a whole separate corollary, unanticipated proceeding that you have to deal with as a collateral consequence.
Let's go down that rabbit hole, because the United States government can hold you in Chrome and debt. The rules are very different. In fact,
and that's another show. That's another show that we'll do, and we'll bring on an immigration lawyer, and we'll have a talk about the dovetailing of criminal and immigration. But again, it is a collateral consequence, and it's one of the things, particularly in a place like here, like Miami or South Florida, where we have so many non-residents and so many tourists. We have that expression here: came on vacation, left on probation.
If you're lucky enough to leave, but Mike, you know this, the Florida Supreme Court, I don't know how many years it's been now, in a plea colloquy, and what I mean by plea colloquy to people is, when you change your plea, you go into court and you stand up in front of a judge, and the judge asks you, are you doing this free and voluntarily? Let's say you're pleading guilty now because you've worked out a plea agreement with the state. One of the things the judge has to tell you, and what they do tell you, and some of the judges that I've been in front of, is you are probably going to get deported as a result of this plea. That's a double-edged sword. Number one, the judge could be absolutely right. Number two, the client's sitting there looking at you like, why should I be taking this plea right now if I can be deported tomorrow? Well,
but again, this is why we have the discussion with the client, so that they're not there like a deer in the headlights staring at the judge going, no, we have already explained this to them. They've already known. And so, look, I'm not gonna speak for bad lawyers or ineffective lawyers. I can only speak for what we do. We are very careful.
I've been caught with that Jimmy Rice clause. Sometimes I forget, because Jimmy Rice, a civil commitment for a sexual
let's
crime.
explain that to the folks.
I will. I will. And for those of you old timers like us, we all know the horrific and tragic story of Jimmy Rice. But the state of Florida had passed a law, this is going years back, for sex offenders. Okay, you can, even if you finished your criminal sentence for a sex offense, in Florida, that doesn't mean, congratulations, you finished your time, or they opened the door for you. No, before you can be released, you go in front of a committee, and it's civil. I know it's civil, but it does have criminal punishments to some degree. That, that some doctors feel that you are just still a danger to the community, even though you fulfilled your sentence. So you can be civilly committed to a facility. Okay, now just put that aside. There's questions with that. What we're talking about is that every single change of plea or the colloquy in Florida, a judge has to tell the individual changing their plea about Jimmy Rice, which makes no sense to me whatsoever, because say you and I are pleading out somebody for a drug trafficking case. We're standing there and the judge goes, are you familiar with the fact that under Jimmy Rice that you can be civilly committed to? And the client's like, what? What just happened?
Again, deer in the headlights, which is something we avoid by having that conversation.
Most judges know this, and they say that, and then they can see the facial expression sometimes, and they're very nice about it. Mr. Morris, Mr. Haber, please, step outside and deal with that. And it's like, yes, because it's confusing. It shouldn't be.
The whole plea colloquy, the whole thing is confusing, which is why it's incumbent upon competent, effective counsel to explain it to the client before they go through it. We colloquy our client before they get in front of the judge.
With this, which I was kind of reviewing before we talked, this is a criminal punishment code score sheet, which you also have to know about and show your client and go through everything. So when people stand up there to change their plea, it's not just some boom, boom, hey, we got an agreement, we got a deal state. No, there's a lot of work to be done by good, competent lawyers to make sure no mistakes are done at that plea.
But understand that talking about pleas is only one aspect. There's Martinez.
Oh my God! Look what
he's actually got a jacket on. You must have actually been doing a Zoom hearing and not bullshitting us.
Somebody hacked.
I really was. I really was, but no tie. Sorry, can't do it.
I'm assuming you weren't in front of Fred Serafin because that would have been a problem.
Really,
he'd have jumped right through that digital feed and choked you out with a tie.
He makes you wear a tie when you're on Zoom?
Yes.
Hey, but you guys probably know this, but your listeners, I was in Broward last week, and this attorney comes in there, and he's got jeans on, some shoes, some loafers on, and a blue blazer and no tie. And I'm sitting there, you know how the
Broward rules.
You sit in Broward, attorneys sit in these chairs, and as each one calls their case, then you move to the next.
Musical chairs.
Okay, yeah.
Musical chairs.
So nothing against Broward, but I'm just a Miami guy through the court system for years, but I've been doing Broward work. And I asked the guy next to me, I go, it wasn't a Friday. There wasn't like, hey, I gave $5 to dress down bullshit. I asked the guy, I said, hey, do judges tolerate the way that he's dressed like that? And, they're like, yeah, some judges let you get away with that. And if you're experienced, you've been around a lot. And I'm thinking to myself, and I tell us, you walk into federal court like that in front of some judges, you get taken into custody.
So they've had, as long as I've been
remember Fred Moreno? Jeez, I walked away from the podium like this one time. I had my hand out. He goes, excuse me, sir, where are you going? And I'm thinking to myself,
Broward.
Get behind that podium and put your both hands on. Like, okay, ooh.
As long as I've been practicing, Broward has had a thing that they called summer rules. And the summer rule in Broward is that you are allowed to wear a coat with no tie. That got extended by just practice to be year-round acceptable. Broward judges tolerate that. And most judges in Dade, for the vast majority of my career, most judges in Dade have been relatively tolerant of respectfully dressed, even if you're not wearing a tie, for critical matters. Like if you showed up for a sounding or something like that, it wasn't a problem. But there are a few judges that are sticklers, and you need to know. But that's part of competent lawyering, right? There's another, in a way, that's another collateral consequence. Because one thing that you have absolutely no control over is who your judge is. I can't speak to any other county in the world, but here in Dade County, imagine a clock. And every single person who goes into the jail gets assigned a number, and that jail number gets assigned a corresponding court case number. And when that court case number is generated, whoever judge is on the 12 o'clock mark gets assigned to the case, and then the clock shifts to 1. And then the next judge at the 12 gets the next case. And it just continues a blind rotation like that. So one of the collateral consequences of an arrest and a prosecution is your judge. Because you can wind up in front of some really difficult and actually some really awful, let's just call truth, judges.
Let me make a point. And I'm sure we'll all agree. When I talk to my clients, when they first come to meet me, the first thing I do is I look at the judge. And one of the things that I can tell them by knowing who the judge is, Mark, you are a prosecutor. I can tell you.
I think what you're talking about is critical. You're talking about scouting the referee, scouting the other.
Here's why it's critical. Just from knowing the judge, I can tell you if the state is going to make a harsh offer or a lenient offer, just by knowing the judge. And a lot of clients don't understand this, but what that means is when Mark and I were prosecuting, if you know, like I was in front of Judge Lenny Glick, right? Lenny Glick was the hanging judge, right? Everybody knew in the jail. Everybody knew.
Hey, before your time, Mike and I can tell you some stories. But
you're going to get the max. Right. So if you're looking at 30 years,
believe it or not, he was liberal compared to some of the judges in that.
I know. But the point for the audience to understand is if you're in front of a judge as a prosecutor, you're in front of a judge that, if you go to trial and lose, you're going to get the max. When Michael comes to negotiate with me, I know I can give a harsher plea. I can say, you know what? I know in any other judge you'd get probation, but I need him to do 3 years. Why? Because Michael's going to turn to his client and go, listen, if we go to trial and lose, this judge will give you 30. So it's important for us to know who the judges are so I can tell my client, be ready or piece of cake.
It's called
Apropos of
handicap.
that, apropos of that, consider that another collateral consequence.
That's what I'm
Because
saying, right?
again,
The collateral
it's something that just exists, and good, competent, effective attorneys understand that this is something we need to manage right from the get-go. To tack on to what Ed said, and really parallel with that, there are some judges that just have a tendency to rule certain ways. The longer they're on the bench, they develop a track record just like anybody else, and you start to see patterns. And so
Right.
there are some judges that we know are absolutely, under those circumstances, going to grant a stand your ground motion. They're going to let it go to a jury. Why? They don't want to be responsible for shit canning a case, right or wrong. Let
Correct.
the jury deal with it. So
They can be
this is
appealed
part of-
on a stand your ground, though.
This is part of, well, but they can get appealed on anything. You know,
Right.
the bottom line is it's part of the collateral consequence of an arrest. It's just another one of those things that we get to kind of think about as we go into a case. Knowing who your judge is very important.
What's the
Also,
first
I'm
thing
sure
we do,
Ed
Mike?
would have.
What's the
I'm
first
sure
thing
that
we do?
Ed would agree that if we know your prosecutor, that's also a helpful thing to us. Because there, for example, and Ed has mentioned this several times in past shows, some cases get assigned to specialty prosecutors. When you get a specialty prosecutor, for better or for worse, the overwhelming odds are you're getting somebody with training and experience. You're not going to have a rookie. Now, that may turn out to be a bad thing because you
Correct.
could wind up with a real hard-ass prosecutor. But at least you're dealing with
Like
somebody who
an
knows what they're doing.
environmental crimes prosecutor, federal?
Or sex crimes or domestic violence
Well,
or
that
any of a
should be.
number of other
I expect
areas.
that.
Yeah, but you know what I think we all, when you're a seasoned lawyer, especially when you're doing criminal, I think what we all enjoy is when we get a special prosecutor, it's smoother even for us because there are certain things that we've been doing this for years that we know is an appropriate plea or something that that the prosecution can introduce into evidence and other things that they're never going to get into evidence. And when you speak to somebody who's experienced, we have a very good conversation saying, look, this is the weakness in your case. You know you can't introduce that. Yeah, I know, I'm screwed there. But when you talk to a guy who has no experience, they don't understand the value of the case.
The other
thinking they can introduce evidence that they're never going to get in. It just
It's
makes
emotional
it
for them.
and
too.
the
It's
other
emotional.
problem with inexperienced prosecutors is they have no authority. They can't do
That's
anything
right.
anyhow. So there's
Right.
no point in talking to them because they got to go to talk to a supervisor and then repeat what you said. And as we all know from the old childhood game telephone line, by the time they tell their story to their supervisor, it's completely different than the story that you told them in the first place. So,
And you still got to be careful because you still got to talk to them, because if you don't, then it's disrespectful. And then when they go talk to their chief or you don't talk to their chief, they're going to tell their boss, oh, he never even asked me. And at the end of the day, their chief is on their team. So they're not going to appreciate that you disrespected their baby prosecutor. So you still got to talk to them, waste your time, waste a whole fucking day knowing that eventually you're still going to have to talk to his supervisor.
Why don't you just ask the prosecutor that's young and say, wait a minute, you're telling me you've got to go to this person, that person, and why am I talking to you right now? Why don't you just introduce me to them? And then we'll come back full circle.
Right, but you just got to be,
Let's go back to our topic because we're running awry here. And I want to get back to this issue of collateral consequences. And really one of the best examples of where we find collateral consequences is in DUI cases. I can't think of a better example because when anybody gets arrested for DUI, you have three things that are occurring all at once. You've got a criminal prosecution for a case that you could potentially be incarcerated for. You've got an administrative action in front of DMV because your driver's license is at stake. And you've got a potential infraction issue, which usually gets lumped in with criminal case, although in some jurisdictions they don't. They actually deal with them separately. But interestingly enough, it's a collateral consequence of any DUI case. You have driver's license issues. If you either refuse breath or urine, then you get an automatic driver's license suspension. And that is independent of your criminal case.
Does this say that on the license? That's on your driver's license.
Literally, it's literally on the bottom of your driver's license.
Yeah.
But you have the right to refuse. You have a lawful right to refuse.
Right.
There's
So
just
does your audience know that?
well, we talked DUI, and we're going to do a full show on DUIs as well, probably two of them, one administrative based and one court based. But the point with the DUI example is that a lawyer who's not familiar with the administrative process is not going to be able to help you deal with your driver's license. Right. And so here in Dade County, if you get a DUI arrest, basic misdemeanor DUI arrest, it's 30 days before you ever appear in front of a judge. But you only have 10 days to deal with it with DMV, or you lose your ability to challenge that administrative suspension. It's a collateral consequence of the arrest. But there's plenty of other collateral consequences of that arrest. Because even if you beat the case, even if you get an acquittal, again, going back to my ridiculous example of an apology letter from the arresting officer and a ticker tape parade from Kathy Rundle herself, even if all that happens, you still have a DMV administrative component to deal with. And depending upon the facts and circumstances of the administrative aspect of your case, you may be required to get an ignition interlock device or an IID. You may be required to get one of them even if your case is dismissed. You may be required to go get counseling and treatment even though your case was dismissed. So, you may have a vehicle impoundment even though your case was dismissed, or a driver's license suspension or revocation, even though your case was dismissed. These are things that you need to think about. Here's another good example, is driving with a suspended license. A good lawyer understands that if you simply plea out DWLS and get somebody a withhold and say, good job, pat them on the back, go home, have a nice day, 3 of those and you're a felony HTO. So a good lawyer understands withhold or conviction makes absolutely no difference. It's the record. It's the cumulative effect of all of these multiple charges that lands you in hotter water. So what do? We explain this to the client. How about toll violations? Have either of you guys ever had some knucklehead client who had $20,000, $30,000, $40,000 in collections because they had 100, 200, 300 SunPass violations they didn't deal with?
I had a husband and wife that he had about 30-something thousand and she had about 20-something thousand.
Those are usually negotiable. But the point is that everything that you're talking about here, when I look at this, the consequences, collateral of a prosecution or being in the system, we talk about being in the system before you got in it. It's financial. It can ruin you financially now and for the future, for who knows. Everything you're talking about right here is money related. Money. You can't drive a car. What are you going to do? You're going to pay Uber? I mean, you lose your job?
Speaking of money, I don't know if you touched on the forfeitures, but for example,
I think we're going to have to do a whole show, or you guys are going to have to do a whole show on forfeiture, because Ed, the other day you brought that up. You brought up, had a little anecdote for that, and it just so happens that this week Mike and I came across a very small one that was associated with a case, and we decided let's just investigate and see what this is all about. Boy, that is another racket that goes on. Okay.
All right. But again, like Michael was saying earlier, if you know the system and you know who the players are, you can get around all the law. For example, on a forfeiture, once they get it and we go through all that stuff, if it ends up going to trial, it's all this government has to prove is preponderance of the evidence.
You don't want to get to
a civil case.
You don't want to get there.
Unless, but there's ways to get around it. They don't want to go either. That's the key. They don't want to go to trial either.
Yeah, you guys may have known. I don't know. I was well known, but there was a Marine, U.S. Marine, and he was driving up in I don't know, it was a state that had a lot of casinos, right? The guy won. Some cash, and not that particular day, but he was then moving, and I think it was like 23 grand maybe in cash, and he gets pulled over, and they do the whole thing, the search, they find the cash. This is a guy that's a U.S. Marine. He's no criminal history. No, that's not how he rolls. They took his money. They took his money. Now, because it was him, a Marine, and other attorneys heard about it, and they went in there and they made a stink. You get a good attorney, you're gonna, then he gets. I don't even think he got it all back though. By the way,
he should have.
Okay, he should have, but maybe he took like a 15. I don't know, whatever. It's the government.
Listen, especially in today's day and age, shit, $23,000 cash. He might have just been going to the gas station to fill up his gas tank.
But the
Good point,
casino
especially
thing,
if he drives a truck like yours, Martinez.
Yeah, I swear to God, sometimes I think I gotta get a loan to get gas. So they
yeah.
have to prove that there's a nexus between the money and a crime. So you could be walking around. I had a guy that had $150,000 cash in his trunk, and they took it, but I was able to get it all back because I was like, "What crime did he commit? What did he commit that you think is suspicious? Very, but you have to have a nexus to a crime. So
what if?
sometimes they don't want to even
Well,
go.
but most of these cases,
Mike, here's a question for you. And what if they find there's a search warrant, and they find 15 grand in cash in the closet, and there's narcotics in the house?
Still not good enough.
The 15 gets seized.
Nope, there has to be a nexus to the drugs.
Would the county?
what if Ed? What if they have confidential informants doing controlled buys on tape?
Doesn't
No,
matter.
no, how about this?
Doesn't matter. They would still have to
how
show
about
that
the
money that they
listen,
found in the closet
guys,
had a nexus to the drugs.
That's not the question. The question is this: if you call up the county attorneys and you say, "Listen, is there anything before I file an adversary, the paperwork to fight that? Is there anything we can agree on to work this case out to go away?" Well, guess what? They will consider having you go away.
Correct.
And they have a little bit of a number for that. So
correct. They don't, like I told you, they don't want to go to trial either. They don't
Well, it
really
depends
want.
on who you are. What kind? If you're a first year lawyer out of law school and you're not carrying yourself correctly or being polite and having some humility and doing these things, you're not going to get anything.
No,
Again,
no.
it's your
Well,
lawyer's talent.
I'm going to give you a real war story. So I had a guy they seized $250,000. I'm going to make it as quick as possible. The reason they seized it is the stop was based on him parking in a handicap space.
Oh yeah, This is the story I was talking about.
He was still on Okay, so I said it last time. He's still on probation. I never said how I worked it out, did I?
I don't remember. I remember the handicap parking.
All right. So he was parked in a handicap. There were 4 undercover narcotics detectives eating lunch just coincidentally at the restaurant he parked. They just didn't like that he got out of a handicap space and he didn't look handicapped. So they came up to him and they asked him for his ID and his registration, and then it all snowballed from there. He was also on probation. Now, they ended up taking him to his house. They seized the $250,000. He literally signed a confession saying that money, those $250,000 cash, came from illegal AIDS medication that they found in his house that he was selling illegally on the black market. So it looks great. Looks like they got him, right? I called up the county attorney and I was very polite and I just cut to the chase. I said, look, the way I see it, it's going to come down to whether they had a right to ask him for his registration, which meant he had to go into his car. And then at that point, they were able to frisk him and Terry frisk and all this other shit. I said, it's going to come down to whether they had a right to do that or they were only allowed to ask him for a driver's license. She says, okay, I agree. I said, and if the way I see it is, it's a 50-50 shot who the judge is going to rule for. She said, I agree. I said, okay, then just give us 50% of it back and we'll call it a day. Took her 30 minutes. She called me back and said, okay, we'll give you 50% back. They don't want to go to trial either. But like you said, Mark, it's got to be a lawyer that can point out to them that we know what we're doing. And if you end up going to trial or having a hearing, you actually might lose. And then they're willing to negotiate.
Yeah.
Let's hop back to collateral consequence.
Mike, the collateral consequences that we talked about this and I made a note and I wanted to bring it up, and that is time. Okay, when you're all kinds of clocks in criminal court start ticking when things happen, when you get arrested to be in front of a judge or your arraignment. So people have to make decisions quickly on what? On lawyers. Who do I hire to be my advocate, to walk through this? How much time do I have? How do I bond out? These consequences, these collateral consequences, they occur the minute that the handcuffs are put on.
That's where I wanted to go with my next point, which was when we take our comprehensive global view of a situation, of an arrest, we're looking at it from a different prism than the individual who was arrested, because most of our clients are first-time offenders. I mean, we don't have a whole lot of repeat offenders. And when people get into the system, they're focused on, they have tunnel vision, which is understandable. I mean, think about it. you're just driving your car on your way home, you know, and the next thing you know, you're handcuffed and stuffed into the back of a squad car, and you're denied the ability to even make a phone call. You're uncomfortable, you're nervous, you're scared, you've got all sorts of things going through your mind. Who's going to feed the dog? How's my wife going to find out? What am I going to tell my boss? You know, just the possibilities are limitless. Now, the three of us are very well aware of this. And so we have to consider things that go beyond just that, what's happening in that moment of the arrest, because the overall process, no matter what happens, even if we're able to secure a dismissal and arraignment, that's still 21 to 30 days away. And during that time, the client has collateral consequence. They've got mental suffering and anguish. They've got financial pressure in terms of legal fees or bond. They have potential marital or business or professional licensing issues. If you get arrested on a firearms or a domestic violence charge, if you have a concealed weapons permit, it's automatically suspended by the state of Florida. These are things that you need to think about, you need to be aware of. And if your lawyer doesn't tell you, and you don't receive that letter from the Department of Agriculture, guess what? You're carrying your concealed weapon and you wind up getting arrested again while you're out on bond. So these are the types of things that we have to think about and to advise our clients, because they are collateral consequences. Time, anxiety. There's another big one. We have a lot of clients who just don't know how to process and deal with the reality of their situation.
And behavior modification.
What's the absolute worst thing that they can do? Self-medicate. And how many of them do that? I'm depressed, I'm scared, guess what? I'm going to go get loaded. I'm going to, get high. I'm going to get drunk. And so now all of a sudden things get really crazy.
Are you talking about the clients or the lawyers?
Both, depending on the client. So, and the judge. And the judge. Certain judges drive me to drink. And certain judges I drink with.
Or the JA.
So we have to be attuned to all of this so that the client can be made aware. And after, you've been doing this long enough, we start to see patterns with clients too, right? There are some clients who just get it right out of the gate. They understand they're not a problem. They don't, hassle us and bother us. They are on top of their own world and their own orbit. They steer their own ship and they follow instructions.
Good career criminals, as you're describing.
Right, but then there's the exact opposite, right? The kinds that need to call you 17 times a day to ask the same question over and over. People that need to be handheld, people that can't tell the difference and differentiate or distinguish between their lawyer and their therapist. So, we work with these people in anticipation of that collateral consequence, right? Sometimes we put them in therapy. Sometimes we tell them, look, if you have a pastor or you have a rabbi or you have, some family member or a teacher or a counselor, whoever it may be that's a significant person in your life that can carry that burden for you, because every minute that I spend wearing my therapist hat is a minute that I don't spend wearing my lawyer hat. And your big problem with me requires me to wear my lawyer hat. Of course, that affects fees too, right? Because when you have a needier client who is going to demand more of your time than is absolutely required or is even reasonably, rationed for a given case, that's going to affect legal fees.
The other collateral I think that a lot of clients miss, I agree with you 100%, but another collateral, since we're on the subject, that clients miss. How many times do we know that we could plead a case out and we could do certain things, and even if the prosecution doesn't want to give us the offer, we know our judge, we know what is important to our judge, we know what our judge is looking for. We ask our clients to do it because at the end of the day, we are a mouthpiece for our client. And so if we say, for example, I had a client that smokes marijuana, they arrested him on something unrelated, on a new case, he's had too many withholds, so by law, the state was not going to give him another withhold. But I knew this judge, and my client is relatively young. He's in his mid-20s. The new charge, he'd been arrested like 7 times for possession of marijuana, essentially. Well, everything had to do with marijuana. For 2 years, I've got him the last withhold, which was also impossible, but I got it for him. But what I told him was, listen, if you're going to keep smoking marijuana, just get a medical marijuana license, because the next time you get popped for marijuana, it won't be a withhold. It was a miracle I was able to get you these last 2. Yeah. 2 years later, he still doesn't have his medical marijuana license. gets arrested for carrying a concealed firearm and fleeing and eluding. And I figured, okay, I know this judge. She'll give me the withhold if I explain to him that this is different from the others and we're not going to have an issue, blah, blah, blah. Sure enough, she was going to do it, but she asked her one question. Is your client willing to submit to a drug test? And he couldn't because he had smoked pot the night before. So this is another collateral. When you got a good lawyer, we tell you, I need you to do this. So when I make this argument to the judge or the prosecutor, I've got a basis for it. They need to do it. And that's another collateral issue. You need to sometimes change your lifestyle so that it's easier for us to get pleas or to do things that we need to do in court. And some do, and some don't.
Easier said than
Some
done,
clients,
you know?
some clients
I'll smoke a
handicap
joint
themselves.
and think about what my attorney Ed told me to do.
Right. Bit him in the ass.
So we do encourage people who are smokers to get medical marijuana cards if they're eligible, and then to follow all of the rules and guidelines, because that's if you have that prescription, it's going to be very difficult for a judge or a probation officer to give you a hard time about fulfilling medical advice from your doctor. You've got a very good argument to be made there. But what about if you're in diversion? Let's say we have a client who wants to get into diversion. That medical marijuana card may do them absolutely no good in diversion because the state attorney's office is not under the same obligation as the court to honor your medical prescription. They're free to reject you from diversion or bounce you out of diversion because of that.
But here's
That's
the good
something.
news.
Wait, you
But
can't
that's
get violated for probation for having THC in your system if you have a card.
No, he's talking about PTI.
Right, no, there's a difference, right? I'm saying there's a difference. If you're in diversion, that card may be meaningless because the state attorney's office is not obligated to put you in that program or to honor your medical prescription. They could deny you the program just because of it.
Yeah, that's another racket for another show.
Right. But I do think most of them will honor it. But here's the other good news. If you've got your medical marijuana license and you get an offer of diversion and you can stop smoking, you can get into diversion. They can't prevent you from diversion because you have a medical marijuana card. What they can say is it doesn't matter if you have one. If you test positive, we're going to bounce you out.
You see,
get your card.
I have a big problem with that because a medical marijuana card is a result of a doctor's and an administrative acceptance, and then you are giving a prescription to go to a dispensary, and you can't purchase anything there without going through a regulatory shakedown. Basically, they sit there, they see what you. So we're talking about a legal. I don't care if you like it or not. It's a legal prescription. Okay, it's law.
Right, but here's the difference. Here's the difference. I agree with you. I agree with you. And when I was a prosecutor, I would agree with you. But what Michael's talking about, the reason is that this is a program that's offered by the state attorney's office. And by law, they do not have to even honor that. They don't have to offer it.
Right.
So basically, they're saying we don't honor your medical needs or your history. That's what I'm saying.
Yeah, that's what they're saying.
But you could say that. We can say that until we're blue in the face. But at the end of the day, the state attorney's office is free to say, that's fine. You choose. If you want to follow your doctor's medical advice, that's great. You're just not taking diversion. Same thing with drug court, Mark. You can have all the prescriptions in the world you want, but you're not taking opiates.
Well, that's no, like it's alcohol. Not. That's different. Alcohol is legal. I can go into a bar, but that doesn't mean that you're not an alcoholic and you can't go through drug court and have to apply. That's very different. I understand.
You're not going through drug court if you've got prescriptions for pot or opioids. It's just not going to happen. Right. It's just contrary to the program.
Obviously, you got arrested because you abused them, or
but you might have gotten arrested for cocaine. Let's say you had a cocaine arrest and you have a medical marijuana card and you want to go into drug court or diversion.
You can't buy cocaine with the medical marijuana card. At least
I understand.
I don't think so. Ed might know.
No, you can't. But the problem, what Michael's trying to tell you is that you can't. It doesn't matter if you have a medical marijuana license. If you go to drug court, they're going to tell you to stop smoking marijuana.
It's called drug court's a whole other.
But it's the same thing with PTI. It's the same thing with diversion.
The state's
drug court's not PTI.
Now, probation is different. Probation is a different story. Probation, they've got to honor your medical marijuana card.
Right. They're governed by Florida statutes. So that's a legal process. Remember, the PTI, the intervention program, is something that the state is offering on their own.
Private. It's privately run.
Look, it's like going to a store. right? This is a product that only the state attorney's office offers, and they have certain guidelines that they want you to follow. You don't want to follow those guidelines, they don't have to offer you the product. That's basically the way they see it. But I will say
I
this, Mark,
just want to,
most state attorneys don't care. Most state attorneys, if you got a medical marijuana card, they'll still give you the
Well,
PPI.
it's
They
the
don't care.
year 2021 now, so I
Yeah.
think people are
Let me-
getting on board.
let me throw one more thing out there because we're winding down on time.
Yeah.
But I just want to mention one more thing about sealing and expungement.
Yeah.
It's not a panacea. Okay. Many people think if they seal or expunge their record, that's it. And that's just simply not true. We started the show with the story that I told about the young lady bank teller who several years later from a different state wound up being disqualified from leasing an apartment because of a case that was not only dismissed, but expunged. But even with an expungement, there are certain things like, for example, if you want to apply to be a teacher, or if you want to apply to get medical licensing, or you want to apply to become a law enforcement certified officer here.
How about get your CDL? I mean, you know.
You have to disclose all of that, even if it was expunged. And if you don't, then they wind up denying your application. In fact, you could be charged for potentially making false statements under oath, which is a felony, if you swear out the form, because it's right there on the form. It'll say to you on the application, even if the case was expunged, you must disclose it. So there are certain.
Well, Mike, what about, let's say you see this all the time. Oh, I want to go into law enforcement. I want to be local. I want to go work for the FBI or something. They're not subject to the same rules of sealing and expunging. They will go right under that and see what was going on.
Well, it's right there in the statute. It's right there in the expungement statute. There are a list of agencies and entities that are entitled to disclosure, even if it was expunged, and it lists a whole series of them. But one more thing that I'll throw out there.
Go ahead, Mike.
It used to be back when I started in the early 90s, I did a lot of special appointed public defender work, and I did a lot of it in juvenile. And we had, repeat offenders were the norm in juvenile court. I mean, we had kids that had 30, 40, 50 arrests by their 13th, 14th birthday. It's absurd. So one of the things that we used to do to try and divert kids out of the system, and this is before diversion existed, there was no diversion then. They had a thing called conditional prosecution or conditional dismissal, but it wasn't a formal diversionary program. So what we used to do was we used to try and use the military as an out, right? Get the kids, ship them off to the Army, ship them off to the Marines. But guess what?
Judge Henry Oppenheimer.
Because now that collateral consequence of the arrest may preclude you from being given the privilege of serving in any branch of the armed services. So it used to be back in the day, we would want to throw the misfits to the military. Now you can't even get in unless you qualify.
Well, some agencies will require you to unseal it. I believe to be a lawyer, you have to unseal it.
But you know what, Ed? If you're the FBI, you should be able to find out who your applicant is.
Yeah, but look, what I'm saying is like the Florida bar. I mean, not the Florida bar, the state of Florida. At least when I got my bar license, they require you to unseal.
Good. Actually, the Florida bar investigators are pretty. These guys are good, ex-Secret Service, and I mean, these guys really dig.
Luckily, luckily for me, my priors were not sealed, so I didn't have to unseal them.
Yeah, the statute of limitations had run on you, Ed.
I was pardoned for that murder, so I'm good.
And by the way, the statute of limitations is pretty much run on our show. So I need to wind us down right now.
Go ahead, you guys do your thing.
I want to thank everybody for tuning in and for watching, whether it's live or after the fact. We always appreciate your viewership. I hope we left you with some quality information. There's a lot more to think about than just jail. Obviously, that's the big ticket item when anybody gets arrested.
Right.
But if you've learned anything from the show, it's that there's an awful lot more to it, and that good, conscientious, ethical, interested attorneys are going to consider these global factors, as I've called them, collateral, latent, and unanticipated consequences of any arrest and any criminal prosecution, because we have to look out for you. It's not just about beating the case. It's about restoring you to righteousness and getting you back into a position where it's not going to come back and bite you in the ass a year or 10 years later.
Right.
With that, we're wrapping up episode 18 of At Your Service with Haber and Martinez with our special guest today, Mark Morris.
Mark, guys, thank you very much for having me as a guest. I always enjoy it.
It's really great to have you. And next week we do episode 19. I don't know what that's going to be yet, but I'm sure that we'll come up with something fun and interesting and promo in advance. In the
Well, in
meantime,
these days,
thank you,
between now
everybody.
and next week, you know, you guys may have more than you can deal with in this day and age, right? All right, guys. Have a pleasant rest of your Monday, and to your listeners and everything, thank you.
And we look forward to being back at your service. Have a great day, y'all. Thank you again.
Bye, everybody.
Bye-bye.